start with why Kavanaugh. From a political perspective, I think there's a reason, not the only reason, but a reason President Trump went with Kavanaugh, because I think that Kavanaugh is one that Murkowski and Collins, the two wobbly rhino senators in the United States Senate, could probably support. And also, potentially, some of these red state Democrats. How do you look at this? Maybe from a judicial perspective, why Kavanaugh?
Well, why Kavanaugh is the question that no doubt Trump was asking himself over the weekend, particularly when, remember, Mitch McConnell said, don't go with Kavanaugh. He's written too many opinions. The Democrats are going to slow walk the nomination, et cetera. But the why Kavanaugh really turned out to be a great idea given the experience and the qualifications that he brings to the table. It is hard to argue, almost impossible to argue that he's not qualified for the job. That's not what the detractors are saying. They're basically saying he's too conservative. But if you write 300 opinions, thousands of pages of text over those 12 years he spent on the D.C. circuit, you'll note that he's come down on both sides of many of these issues. Yeah. So he will be able to woo the more moderate senators like the two you've mentioned, and even maybe grab some Democrats like Neil Gorsuch did.
Yeah, I don't think he's too conservative at all. But again, look at the perspective here. Now, I've heard some wild conspiracy theories as to why the president, from the Democrat, from the radical left, why the president chose this nominee, that he made some sort of deal with Justice Kennedy to retire, and if he retired, that he replaced him with Kavanaugh. And then there's the Mueller link to this, and whether a sitting president of the United States can be indicted or not. And Kavanaugh wrote about this in 2009 in the Minnesota Law Review, and this is a portion of it. Read it real quick. I believe it is vital that the president be able to focus on his never-ending tasks with as few distractions as possible. The indictment and trial of a sitting president, moreover, would cripple the federal government, rendering it unable to function with credibility in either the international or domestic arenas. Such an outcome would ill serve the public interest, especially in times of financial or national security crisis. This will necessarily, whether you agree with him or not, and I happen to agree with him, and he's, by the way, agreeing with precedent. We'll get into that in just a minute. The bottom line is this is going to come up during the confirmation process.
It certainly will, but this is not a view that is held just by Judge Kavanaugh. That is the prevailing view, that you cannot indict a sitting president. The fact that there may be issues involving the president or the executive branch that come before the Supreme Court is not a reason to say he cannot be confirmed. It's not even a reason to say he necessarily ever has to recuse himself. That's a very high standard. So while true, it is something that will no doubt be the subject of rigorous questioning at the confirmation hearing, it's not going to be a bar to him being confirmed.
No, because it's DOJ policy. It's current DOJ policy as prescribed during the Nixon administration and then reaffirmed during the Clinton administration. But also, if you look at the big picture from a constitutional perspective, it seems as though the courts should have no role in choosing whether the President of the United States and deciding whether the President of the United States is corrupt or criminal or not. This is a matter of impeachment. This is the Article I powers of the United States Congress.
And that's what Judge Kavanaugh said in that Law Review article, that he said if there is, and I can't remember how he put it, it was actually quite interesting, misconduct, shall we say, impeachment is available. So what he basically said in that article is laid out the prevailing view that is still the prevailing view today, and it should not cause as much furor as we anticipate within that confirmation hearing.
And in essence, I think what he's saying here and what I'm saying is that if a single entity, a judge or even a panel of judges, come in and indict the President of the United States, they're necessarily overturning the will of the people, the majority of the people through the electoral system who installed the President of the United States. But we have to, I think, look at all this through an interesting prism here. That's another component of Judge Kavanaugh, and that is the residue of the Starr investigation. He helped co-author the final report.
That's right. And what's interesting about that, Graham, is the fact that he co-authored the Starr report, where obviously that had to do with Bill Clinton and the impeachment and lying to the public, and then evolved his views sufficiently to pen that 2009 Law Review article, shows his views can change if and when he's presented with information that leads him to change his opinion. That should be a good thing. That actually should be a quality that maybe could even sway some of the Democrats to think we can't necessarily assume we know how he's he's going to rule on the tough issues. Now, that's not going to have conservatives very happy, but isn't that the mark of a good jurist, that they are somebody that's going to faithfully interpret the law, not make the law,
right,
and not allow your decisions to be really affected by your personal opinions? That's something that in his confirmation hearing for the D.C. Circuit, he promised he would never do.
Want to see more videos like this? Click on the link below and subscribe to One America News on YouTube, and call your cable provider and kindly demand that One America News is added to your lineup. Call and subscribe today.